Tar Hill Preferred Insurance Company.
Good morning.
Morning.
Please the court. George Vaca on behalf of Mr. Lantier. I'd like to ask the court if I could reserve, please, 5 minutes for rebuttal.
All righty.
Judge Kelly, this is close to Groundhog Day, but not Groundhog Day. It does present another case involving the interpretation of the sinkhole statutes, but FIGA is not involved in this one, thank goodness.
Yeah, this is a little different spin.
And this is the first case I'm aware of to make it to the state appellate level concerning the issues that are raised in this case. Briefly stated, in January of 2010, Mr. Lantier noticed cracking to the walls, floors, ceilings of his home. He timely reported a claim to Tower Hill, who assigned a sinkhole investigation to SD2, who in April issued a report indicating that there was in fact sinkhole damage to the structure, and in which it made a recommendation for remediation of the ground, and also advised that there was cosmetic damage above the foundation to be repaired. SD2 recommended chemical grouting and cement grouting, which basically cost about $73,000. It did not believe that there was significant damage to the foundation, at least as reflected in the report. And Tower Hill took the position that Mr. Lantier was to enter into a contract for remediation of the ground in accordance with those recommendations. Mr. Lantier, after consulting with the public adjuster, requested neutral evaluation in accordance with the statutes. Following the neutral evaluation, the neutral evaluator came back with a recommendation that required 50% more grout than the SD2 recommendation. It was at a cost of just a little bit more than 2/3, I believe, more than the SD2 estimate of $73,000. And at that point in time, Tower Hill adopted the report of the neutral evaluator and advised Mr. Lantier they would have to enter into a contract for remediation not in accordance with SD2, but in accordance with the neutral evaluator. Mr. Lantier was not particularly convinced of the correctness of either of those, and went out and hired his own engineer, Mr. Galati, who was of the opinion that yes, there was sinkhole based upon the information that he reviewed, and that there needed to be additional remediation efforts, specifically perimeter piers around the perimeter of the building. He gave an estimate of the cost of that, which I believe was somewhere between $200,000 and $225,000. Mr. Lantier then entered into a contract with Champion Foundation to accomplish those repairs in accordance with Mr. Galati's suggestions. They were submitted, that contract was submitted to Tower Hill for its approval, and in September of 2011, it wrote back and said, no, we're not going to approve this. You need to enter into a contract in accordance with what the neutral evaluator said, and then this lawsuit ensued. In the lawsuit, Mr. Lantier maintained that he had submitted a contract for the repairs, that it had been rejected, and that Tower Hill had breached the contract.
Let me just ask you a background question real quick to get this out of the way. After the 2011 amendment, in this case predated it, is there still an issue that you have to, that the insured has to enter into a contract with the insurer's expert?
The legislation that was passed, in my opinion, clearly dictates that that's exactly what the insurer is required, and the insured is required to do.
And they're claiming it was that was just a clarification of what the statute provided pre-2011, but really the Senate analysis says constitutes changes.
Substantive and, yes.
I mean, the policy behind all of this payee in data is to avoid people walking away from sinkholes without fixing it and taking the money and running, let's say.
That's the argument, and that's the policy that was advocated by Universal in front of the Warfel Court to tell the Supreme Court that that was the justification for the presumption of correctness. That
how is that policy furthered in this case when it's an argument as to who the payee should be, and it's an amount in controversy? The amount's a lot higher with Galati's recommendations.
It's not a question of, is somebody going to take the money and walk away from the property?
Not in this case.
The question here is, what is the proper method of repair, and does the homeowner get consulted? Because the argument that's been made by Tower Hill is very simple. It's our way or the highway. You accept what our recommendations, our engineers' recommendations are.
Wouldn't that be a question of fact if there was a consultation with the insured?
That was one of the points that we raised below to suggest to Judge Bray that this summary judgment should not be granted, that there was not a consultation, that the policy and the statute required it.
Consultation is not defined, but you're saying it's something different than informing you this is what we're paying.
That's certainly what the dictionary definition would suggest.
I mean, how does an insured contest the reasonableness of the amount if they challenge the report saying that's not enough to fix my house?
According to Tower Hill, they don't have the ability to make that challenge. According to Tower Hill, you are to accept the proposal of their engineer or the neutral evaluator.
You know, I guess what bothers me about the interpretation you're suggesting is the contractual language in the statute says the engineer, not an engineer.
And the is not referred to. So the then gets...
Yeah, but if you look at it in the context of the statute that requires them to go out and have a professional engineer come and evaluate, I mean, essentially what they've argued. I mean, you know, to be honest with you, that I think that interpretation and reading everything together makes sense, and it seems more of a stretch to me to look at this and not think about the word the and insert and come up with this concept that the insurer can just go out and get someone and override all this other work and evaluation that's been done.
Actually, Mr. Vaca, the main reason to follow up with that, because the insured is really not without recourse, because if you don't agree with that, what's your fallback? The policy says that then they tender the whole entire policy limits to you. That's within. It says that we either complete the professional engineer's recommended repair or tender the policy limits to you without a reduction for the repair expenses incurred. So you have that as part of the provision. So I wanted to throw that in so when you respond, you could respond to all of it.
Well, I think if you walk that logic down the road, I think you run squarely contrary to what the Supreme Court said in Warfel. If you accept what they're saying, which is that their suggestion is presumed correct for purposes of litigation, which is precisely what the judge ruled here, you're smack flat dab in contradiction to what the Supreme Court said in Warfel, which is any presumption of correctness is for pre-suit only, for purposes of trying to protect the engineer or the geologist or wherever the professional is from a slander of title or some type of tort action later on. So in this particular case, there has to be some way for the insurer to be able to challenge the reasonableness of the repair. Now, one way to do that, the legislature already provided for, which was neutral evaluation, which, again, according to, if we accept their logic, they can opt out of neutral evaluation altogether. That's not what the statute provides. It's if somebody requests it, it must happen. So I think we need to read their policy language in the context of all of these things, not just as narrowly as they would like to have it read. For purposes of the if it doesn't work part, if the purpose of the statute is to have the home repaired, then it seems to me that that purpose is being fulfilled if there are multiple professionals who are contributing to the plan as to best repair the home. Because under this interpretation that we're going to do it, and if it turns out it doesn't work, we'll pay you the limits, the very purpose that they're saying is that this statute is based is left unfulfilled, which is the repair of the property. And that's not what they argued below either, Judge Guzan. What they argued below was, this is just a starting point. And if you don't like the repair, you can come back and sue us again. That was their cure. That was their remedy to what the problem was, is sue us again for the breach of the repair. And if you accept that remedy, then the question arises, okay, are they precluded from later arguing that, hey, wait a minute, this damage wasn't as a result of this sinkhole, but it was as a result of settling, cracking, or some other sinkhole? Was it the result of some other ongoing loss? All of those questions are left unanswered. And it seems to me that they've proposed a remedy for that's far more problematic than the problem that they seek to cure. So we say, wait a minute, let's do this in a logical fashion. Let's forget that this is sinkhole for a second. Okay, this is just insurance. It's a kind of insurance. Why wouldn't we be able to contest? If it's a repair case, if it was an auto case, why wouldn't we be able to contest the method and the means of repair? In no other context I'm aware of that you don't have the ability to contest that. They've not offered any legislative intent to prevent that. They do in terms of the 2011 statute, but not in terms of the 2005. Certainly the legislation couldn't be clarified 6 years later as a clarification of a statute that they argued in their brief was a clear and unambiguous statute in 2005.
So you're saying the insured could never get to neutral evaluation under the insurer's interpretation of the statute?
They would never have the ability to do it because they would be forced to enter into a contract for repairs in accordance with their engineer's report.
Then what would be the purpose of the neutral evaluation statute?
There would be no purpose to it. There would be absolutely no purpose to it. If we were required at the end of the day to always enter into a contract based upon their engineer's recommendations.
And if you get to the neutral evaluation, since that's not binding, that's something that could be contested as to method and manner and amount.
Correct. And in this case, really what the interesting part of this case is, factually is, they got to that point and then they abandoned the interpretation of the contract that they're advocating in front of this court and what they did in front of Judge Bray. Because what they said there was, you have to opt into accepting the NE's report to get the benefits, the no attorney's fees, the shield from bad faith. They opted into that and said, okay, well, wait a minute, don't accept our experts. Now you're going to have to accept neutral evaluation. Their contract doesn't say anything about that.
But they didn't tender the amount either.
No, because we still didn't have a contract in accordance with the neutral evaluator's recommended repairs. And our client didn't agree with either their expert, which happened to be the same expert that was rejected in Warfel, didn't agree with the neutral evaluator, and hired his own. And it's not like this is like math where it's 2 + 2 = 4. This is kind of science and art. There's different opinions. And so what they're saying is they're saying exactly what the 2011 legislation said. You got to accept ours, period. That's it. You have no choice. Now, their interpretation also writes out the in consultation part, which you then have to assume that part of the legislation has no purpose if you accept their interpretation.
Let me ask you a question, Mr. Vaca. Let's just assume the expert that you found, I know what you've done in this case. You had a contract, you sent it over to the insurance company for them to approve it. What would have happened if your client would have signed that contract?
My client did sign that
Okay,
contract.
did sign the
Yes.
contract.
My
So
client
did you-
signed the contract, and it was signed by Champion, and it was
It
submitted
was a
to.
conditional contract, though.
Correct. It's
Okay.
it's the same contract that was submitted in the Lumpwe case.
Okay, so I guess my question, and I'm glad Judge Valenti clarified that. I meant to say, take away the conditional aspect of it. Your client signs off. What would their position be? I mean, you have to follow your argument that you have, the contract was in fact entered. Are they then on the hook to?
If you take their argument literally, I guess that's what the result would be.
So would your position be stronger if it was not a conditional contract?
Maybe our legal position would be, our real-life position. I suspect they would have said, we're not paying for this because we're only going to pay for the neutral evaluation, and then our client would have been in the position where he was liable on a contract.
Well, they're arguing now a contingent contract is really not a contract.
Well, that's
Plus,
not,
you didn't enter into the contract with the people that we approved.
there's nothing in the statute, nor there is nothing in their policy which requires that. Their policy requires that you enter into a contract. There was a contract which was entered into, the purpose of which was to perform the repairs on the insured structure. That's all that was required of our client. And frankly, I think it was a little bit of foresight. I mean, and again, to submit it for approval, it's almost if you're going to a doctor and you want to make sure that the surgery the doctor's recommending for you is going to be covered by your insurance. So you go get pre-authorization for the surgery. And although the contract didn't, the policy didn't require this, and the statute didn't require it, there was nothing that prevented it. And so we then get back to, okay, when they don't approve it, is there a consequence to that?
Well, you were trying to tee up the issue, let's say. What do they do to advance the case? Either they do a contract that they think is appropriate to get the house fixed, or they cave in and, no pun intended, and agree to what the insurer says, this is what you're limited to, and live on the edge until the house collapses, or it turns out the insurance company was right. They don't know, but they don't want to take that risk. Or they file some sort of a deck action, which I think was done in one of the other cases that were briefed. But in this case, they just filed a breach of contract action.
Correct.
And how do you factor in the duty of good faith that's imbued into any contract?
Well, what we argued below and what the Lumpwe case suggests is that every case in which there is some discretion afforded to one party or another requires that party to exercise the discretion reasonably and in good faith. And I'm not talking good faith in the terms of typical insurance parlance. I'm talking about it just in typical contractual parlance.
But you've got a battle of the experts essentially here. Isn't that normally what's resolved at a jury trial?
Which is what we suggested to Judge Bray, and Judge Bray ruled that we absolutely did not have the ability to do that.
Even though this is a pre-2011 case?
Correct.
Mr. Vaca, you're at your 5 minutes.
Thank you. I'll reserve whatever time I've got left. Thanks.
Thank you.
May it please the court. Good morning. My name is Anthony Russo. I represent Tower Hill Preferred Insurance Company. I would like the court to know at the outset this is not a forfeiture case. And I point the court to the affidavit of Mr. Timothy Ferguson, an official at Tower Hill at record 239, paragraph 5 and 7. He says, Tower Hill stands ready to make further payments to the plaintiff once he enters into a contract for sinkhole remediation, and then down to paragraph 7, in accordance with, and this is important too, the recommendations of SD2 or the neutral evaluator, comma, which are one and the same. Our position in the trial court is that the SD2 contract or report and the neutral evaluator's report are one and the same. As proof of that, I go to the summary judgment evidence, which is the neutral evaluator's report at record 277, the second page in the conclusions. The neutral evaluator says, based on my experience with similar subsurface conditions, these subsurface grouting recommendations in the SD2 report appear to be adequate to treat the sinkhole activity encountered at the subject residence, comma. However, I suggest adding 2 grout injection points with additional grout. We accepted that. Our position is the neutral evaluator agreed with SD2, said add some more grout. We said, okay, let's resolve this. He rejected the underpinning methodology that was suggested in the FTE competing report. In the neutral evaluator report, there's another important point that goes to the issue of consultation. On the first page, the neutral evaluator says, here's what I did. I went to the Lantier residence and I met Mr. Lantier, Ms. Tanya Gray, and Karen McLeave, the Tower Hill Company representatives, Mr. Stephen Meggs, the professional engineer from SD2, and Bill Potter from Florida State Insurance Adjusters, the public adjusting firm representing Mr. Lantier. They sat down, they observed, they talked about...
Yeah, but isn't that an argument pertaining to a factual interpretation of the term consultation? I mean, I can understand that your position is, well, that looks like a consultation to me. However, at the bottom line is at the end of that consultation, it's just basically the carrier saying, and therefore this is what we are going to do. Nothing more, nothing less, but this is what we're going to do. And the insured saying, well, let's talk about this. I've got this report here, and so we reject that report. So I guess what I'm saying, that could be a consultation, but
yes.
A consultation could also be something involving some give and take or some additional dialogue. Why limit it to the facts of this case? Say that's a consultation as a matter of law. And if it's not, is that ripe for summary judgment?
It is ripe for summary judgment. There was give and take, and the give and take was at the neutral evaluator when we accepted that those additional grout points and additional grouting. There was also, Your Honor, the matter of the letter after letter that we wrote to Mr. Lantier and the absence of any summary judgment evidence from the plaintiff that there was no consultation. And if you look at his complaint, he mentions the word consultation, but he doesn't say we breached the contract by failing to consult. That came up later, but it's not pled in the complaint.
But it's raised on appeal.
Yes.
And we're talking about it, you know?
Right, right.
Okay.
But there was give and take, but I would say that the summary judgment evidence is conclusive that there was a consultation and that there is no jury issue.
Do you agree with the good faith should be implied into every contract, including the insurance contract?
I believe that was the holding in a case from the Supreme Court last year or the year before, Your Honor. I'm not sure the exact parameters of it or how you're thinking that it applies here.
It's just that, you know, consultation, good faith, these are all terms of art.
Yes.
And there's no definition per se in the contract. So we're getting case law, throwing it in there, saying use that. We're using some parts of the policy. We're trying to figure out what these words mean. And then we're saying, and you lose as a matter of law. I find there was no breach of contract.
He hasn't lost his contract rights, Your Honor, but he has lost his
Well,
claim.
the judge found, I find as a matter of law there was no breach of contract. This is not a debt case. This is a breach of contract case. And I'm just saying all these moving parts and ambiguous terms that really don't have one definition, how do you rule as a matter of law?
By going to the statute, because to borrow a phrase that you used earlier, Judge, this is a definition-driven decision.
That was the last case.
Yes.
I already forgot about that.
To refresh the court's memory, it is not a presumption-driven decision, as my opponent would want you to believe. Their presumptions of Warfel played no part in our argument. We disavowed that. We're not relying on Warfel or presumptions. 627.707 tells insurance companies, look, when you get an insurance claim, number one, go investigate. Number two, subparagraph 2, it says, go engage a professional engineer. And you make that professional engineer give you a report under point 627.7073 that is laid out in a specific regimented manner. And that report will control you, insurance company, on what you do. And in the statute 627.707 paragraph 4, if that report comes back and says no sinkhole, the legislature says the insurer may deny the claim. That's what happened in Warfel. Then there was a trial. Then there was a jury issue, and the presumptions and all of that became the issue that you're also well aware of. This isn't Warfel. In this case, SD2 came back and said, there is a sinkhole. In Warfel, they said, there isn't. So
What would happen, and I agree, Warfel's a little bit different from this case.
Very, yes, sir. Yeah.
What would happen, and help me out with this, the SI2, the neutral evaluator, come to a conclusion. What if they are dead wrong? Totally dead wrong in terms of the methodology about that. What is the insurers, what is their remedy right now? What can they do?
The remedy is found in subsection 5B, Your Honor, and it was alluded to earlier, of 627.707. If the engineer retained by the insurance company determines that in the course of doing the repairs that the house cannot be repaired according to the plan, and the insurance company repairs it without regard to the limit or pays the policy limit without regard to what was paid before, and the policyholder is made whole. And that professional engineer has a very strong financial incentive to say, hey, if this isn't going right, insurance company, you pay because I'm not guaranteeing these repairs. I'm going to get sued by the homeowner later. That's how the policyholder is protected.
So basically, then an insurer has to rely on the professional engineer that is hired by the insurance company or the neutral evaluator, and are they prohibited
Yes,
from
correct.
getting any of their own expert to counteract that?
That's right, Your Honor, and that's what's been overlooked here. Under 5A, if the legislature says if a sinkhole loss is verified, the insurance company shall pay to stabilize the land in accordance with the recommendations of the professional engineer as provided in .7073. So if SD2 came back and said, there's a sinkhole and you need to put underpins in that house, Tower Hill couldn't say, we agree there's a sinkhole, but we're going to use grouting. Let me tell you, my opponent would be saying, no, they must go in accordance with the underpinning recommended by their own person. We cannot deviate from that report. That's what the law says. This law was put in place to make sure that insurance companies adjust and pay sinkhole claims in accordance with scientific and technical terms and using professional engineers and professional geologists who are guaranteed their professional independence under 627.7072 and who have to write a report in a statutory format under the next section, 627.7073. That statute, 7073, there's one person who issues a 7073 report, and that is the professional engineer or the professional geologist who is engaged by the insurance company pursuant to section 627.707, parent 2. Mr. Gelati and Florida testing is not controlled by or regulated by the .7073 statute. There is none of the statutory protections involved that adhere to Mr. Gelati and FTE. And if we used the Champion repair, if we use their repair, then Mr. Lantier loses the protection in section 5B that the insurance company pays,
But as I understand you, Mr. So they really cannot, I hate to use the word prohibited, but they are prohibited from really going and hiring their own expert, because based on what you said, the insurance company's obligation is to hire an expert, is to have that expert prepare a report pursuant to the requirements
Yes.
set forth. So it goes back to where that if your expert, if the professional engineer was so totally off base, totally ridiculous, saying, yes, there's a sinkhole, but I think we should just put some light,
Right.
covering, something ridiculous like that. The remedy for that is that the insurance company then will pay the full policy limit, or can they go and they say, it now triggers for them to hire their own expert to say, this is what needs to be done. I'm just trying to find out, do they have any remedy whatsoever to
Well,
counteract?
I think, Judge, in your hypothetical there, they could assert that the report that was obtained by the insurance company was deficient. And actually those allegations were made. Mr. Gelati said in his affidavit that I think the tower, for instance, that the SD2 report was deficient in 2 ways. Number one, it doesn't address foundation repair, and I'd like to address that. And it's insufficient to support the foundation. Number one, I'd ask the court to look at, that's not correct, the summary judgment evidence, which includes the SD2 report at page 965, does address the floor elevation and says there that there is minor differential foundation movement. The total elevation of approximately 0.4 inches is considered to be within construction tolerances and is not indicative of differential foundation movement. On the next page, the observed cracking on the garage and exterior is minor, is consistent with material shrinkage. These damages do not have a significant impact on the structural integrity or required design capacity of the walls. It's within construction tolerances, those 3 pages. The report doesn't provide for repairs to the foundation because there's no damage to the foundation. So that's the summary judgment evidence, and that's why Mr. Gelati's affidavit fails to create a fact issue. As to the other argument he makes that it's insufficient because it doesn't give a repair protocol that's sufficient to support the building, is because that's just a disagreement with the conclusion. It's not an allegation that the investigation or the report of SD2 was insufficient. In fact, he uses the SD2 report for his report.
Well, who invoked the neutral evaluation process?
Mr. Lantier did.
Okay. And you agree he had a right to do that?
Yes.
But under the insurer's position, it seems to me that guts the neutral evaluation process. How does that go to fruition if it doesn't affect the
Yes.
outcome?
Say that SD2 came back and said, no sinkhole. Mr. Lantier says, I want to go to neutral evaluation. The neutral evaluator said, no sinkhole. Mr. Lantier doesn't have to accept it. It's not binding on him. He can go to court and we'll have a Warfel case. That's how neutral evaluation makes sense in all of this and how it fits in. But under this contract and under these circumstances and under this policy, there is
So you're
no
saying
fact
neutral
issue.
evaluation doesn't apply if there is a sinkhole and the carrier agrees there's a sinkhole?
Oh, it applies. Yes, and in fact, we went through it and abided.
I'm trying to follow, because it seems to me this neutral evaluation process doesn't apply in a case where there is a sinkhole, because they never get to exercise the fruits of that process if the carrier says, this is what we'll pay, take it or leave it.
Well, the neutral evaluator agreed in this case with Tower Hill with those 2 minor differences, and we accepted it. I don't know that the legislative scheme is perfect or provides for anything else, but I know that the legislature clearly says in the pre-2011 statutes that it is that 7073 report that controls the insurance company's obligations. And what was made explicit in the post-2011 statutes is at least judged necessarily implicit in the pre-2011 statutes.
Well, we have a pre-2011 case here,
Yes.
so.
Yes, we agree that the I think at the hearing people were the parties agreed that the 2010 version of the
I mean,
statute applied.
should there be a difference in application on the
There is not.
pre-2011 statute versus the post-2011 statute?
No, sir. This
But the Senate analysis in that bill uses the term changes in the statute, doesn't say clarification.
Well, I recall that in section 21 let's see, 2011 Florida Session Law Service 2011-39, paragraph 3, pursuant to sections 22 through 27 of this act, technical or scientific definitions adopted in the 2005 legislation are clarified to implement and advance the legislature's intended reduction of claims and disputes.
Okay.
So that word does show up.
So then my last question, because I know we're asking a lot of questions, how do you distinguish the Lumpley versus Scottsdale insurance case Came out of the Middle District last year.
I believe that was the Scottsdale case,
Right.
and that does not, so they are not controlled by, as the surplus lines insurer, they're not controlled necessarily by Chapter 627, and there was a question, that's the distinction, Your Honor. And it's drawn out clearly in a much more articulate manner in our answer brief, and I would rely on that, Your Honor.
All right.
So the consultation, David, the affidavit of Mr. Salati. The contingent contract, Your Honor, I don't think that's an issue that really plays directly into the issue that's presented to the court today. We did make that argument, rely on it, we're not abandoning it. However, I don't think it gets to the heart of the issue of our argument. It's not a battle of the experts, Your Honor. I think that the statute, the 2010 statute, as well as the post-2011 statutes, say that when there is a report by that engineer engaged by the insurance company, it controls what the insurance company does and what it pays and what the policyholder is entitled to.
Thank you.
Thank you.
Thank you. Let me address a couple things. We made a reference to Lewis Carroll in our reply brief, and I think it's somewhat apropos in that Tower Hill takes the position that a repair contract for $73,000 is the same thing as a repair contract for $123,000, when it clearly is not. The neutral evaluator suggested 50% more materials be used than the recommendations of Tower Hill's chosen expert. I think by anybody's definition, that would be a significant material difference in those proposals to make them not the same. Just to go back to the contract and your questions, Judge Volonte, about the failure to consult, it's specifically alleged at paragraphs 12 and 13 that the client was not consulted and that he was told unilaterally that he was going to have to take on what Tower Hill told him he was going to have to take on. So it is specifically addressed, and I believe that's page 2 of the record. The issue about the 2005 and the 2011 statutes is at best puzzling for me. If you look at the legislative history, there were a lot of things that were going on. Specifically, the legislature wanted to legislatively overrule this court's decision in Warfel. The Supreme Court had not yet issued its ruling. And it made what it deemed to be significant changes in the language of the statute. And one of those changes was in 627-707, subsection 5. Now, you've heard it suggested to you that this was just a mere clarification, and I would suggest to you that when the legislature wants to clarify things, it does a couple of things in the course of the legislation. One of those things is it usually says it's a clarification, just as the legislature did with respect to first-party bad faith cases in the uninsured motorist context in 627.727 subsection 10. It went back and it specifically said this is a clarification of what the statute is. That's not what this 2011 statute says, and the staff analysis specifically says otherwise. If you look at the language of the 2011 statute, the legislature has said that if a covered building suffers a sinkhole loss or a catastrophic ground cover collapse, and then it adds this language, the insured must repair such damage or loss in accordance with the insurer's professional engineer's recommended repairs. It then goes down to 5A, and it says, until the policyholder enters into a contract for the performance of the building stabilization or foundation repairs in accordance with the recommendations set forth in the insurer's report issued pursuant to 627-7073. And the question that Tower Hill has never answered in this case, and they cannot answer, is why would the legislature go back and create these substantive changes in this statute Why would they go back and do all that and completely rewrite the sinkhole statutes if this is what was already in existence in the predecessor statute? And the case law on that's pretty clear. It says you can't assume that the legislature is going to go through a useless act. There must have been a purpose. And there was a purpose. And that purpose was to significantly change the rules of the road as it pertains to sinkholes. Now the insurer got their way. And there are issues about that. And we're not here to argue about them today. There will be discussions about access to court and all sorts of other things in the future. But as it pertains to the contract that is in play in this case, this statute altered the rules of the road. And there would be no purpose for neutral evaluation if it is, as Tower Hill contends, that we really only used neutral evaluation to determine if there's a sinkhole or not. The statute itself doesn't even talk about just sinkhole. It talks about sinkhole and or the methods of repair. So it would seem that those two statutes would be in conflict now, but they weren't then. And I just want to kind of wrap a couple things up. Last thing, Lumpy. Lumpy was a surplus lines case, which meant that at Scottsdale's suggestion, any reference to 627, period, was wiped out of the complaint. It was stricken, and the case was considered as a contract-only case. The sinkhole statutes had nothing whatsoever to do with it. And there, Judge Bucklew determined, in a case factually almost on all fours with this one, that there was a question of fact regarding consultation, there was a question of fact regarding what was the best method of repair, and there was a question of fact as to whether or not the insurer unreasonably withheld approval of the conditional contract by Champion submitted to it to perform the repairs that the insured said was required to the home. That ultimately resulted in a jury trial in which the jury found that the insurance company did breach the contract by unreasonably refusing to approve the contract of Champion. And it did approve, as the best method of repair, the recommendations of Mr. Galati. And all we're asking for is to have that same opportunity, is to let a jury determine whether the neutral evaluator suggested repair or SD2s, who they say the statute mandates we require that we go through with that, or whether it's the recommendations of Mr. Galati that should carry the day.
Thank you.
Thank you.